The last case today is Banks Trust versus BASCIANO.
May it please the Court, my name is Kimberly Ashby. I represent the appellants, who are Lennar Partners, Inc., and Bankers Trust Company, who is a trustee for the trust that held the note and mortgage in this case. We're asking the Court to reverse the final judgment for a variety of reasons. This final judgment cannot stand because the oral negotiations for a loan restructure as a matter of law cannot give rise to either a negligent misrepresentation claim or violation of what's been called FDUPTA or FDUPTA, the Deceptive and Unfair Trade Practices Act in Florida. In this iteration of the FDUPTA law in 1999, it was a requirement that you show that you are a consumer in order to have any sort of recovery under the statute. And in this case, the plaintiff, Mr. BASCIANO, cannot show that he was a consumer. And what he pled in his second amended complaint at paragraph 69 was that he was a consumer of loan services. If that's true, then that forever and always is trumped by the banking statute of frauds, which is 687-0302. So as a consumer of loan services, Mr. BASCIANO cannot recover because the oral agreements that were never reduced to writing are completely covered by the banking statute of frauds. In addition, the parties signed a pre-negotiation letter in April of 1999 in which they said to each other, nothing that we say to each other shall be binding unless we put it in writing and it's signed by both parties. And no conversations will give rise to any sort of litigation. So at the outset, the parties acknowledged between...
Does that mean that they waive a claim for fraud, for example, a tort? Can you waive a tort in advance of it happening?
I'm glad you raised that, Judge Torpey, because one of the issues that the appellee raised in their brief was that there had been some waiver argument that this letter didn't apply. You can't release your fraud claim in advance. So you can't sign a release today saying, I can perpetrate fraud on you in the future. That's against public policy. But the release language is only part of the pre-negotiation letter. It releases all of the claims that the parties had by and between each other through the date of execution. And then it's the representation language and the failure to be able to reasonably rely on any conversations, oral conversations that you have. That's the teeth of that April letter. And at summary judgment, just as at the close of all the evidence, there was no dispute that Mr. BASCIANO signed that letter as a legal representative of the borrower. The borrower was an LC. He signed it as the managing member. The LC cannot operate in any other way than through its managing member as a legal representative. It can't mean anything else. The letter itself said very clearly that the terms of that letter were binding not only on the borrower, the capital B borrower, which we know was 3835 McCoy Road, but also on the legal representative, which by definition was Mr. BASCIANO. And when he signed that letter, he signed it managing member, and I'm sure on purpose so that he would not expose himself to any personal liability. So that is another reason why summary judgment should have been granted in favor of the defendants in this case. All of the counts and the remaining counts that were left at the...
Could you help me out with the negligent misrepresentation claim? What's your argument with regard to that?
The negligent misrepresentation claim fails for all of the reasons that we're talking about. Fails for the banking statute of frauds, because of the pre-negotiation letter, because the...
Well, I guess maybe you need to help me with, maybe counsel needs to help me with what their theory is, their factual theory. I thought their factual theory was that there was a misrepresentation made by the bank about when they received the appraisal. And as a consequence of that, the plaintiff continued to fund this hotel to tune of $360,000. Is that their claim?
The claim is that the appraisal information should have been turned over at the time it was received. You can't negligently.
Was the claim that was the evidence in the light most favorable to the plaintiff that they failed to disclose or failed to turn over the appraisal, or that they affirmatively misrepresented the fact that they had received the appraisal?
That they had, well, the jury found no fraud, so there's no intent by definition. But what their theory was.
Maybe the banker didn't know that he had the appraisal, but in order to have a misrepresentation claim, doesn't there have to be an affirmative misrepresentation of a material fact?
Yes.
Whether it's negligent or fraud?
Right.
Okay. What was the evidence on that point? Wasn't the evidence that the banker told the plaintiff that he had not received the appraisal when in fact he had?
The evidence was that Mr. Brown told Mr. Walsh and Mr. BASCIANO that the appraisal wasn't in yet. We're talking about a matter of days, in early January, and the appraisal itself is dated December 20th. And there isn't any evidence one way or the other when that actually was received. We know it couldn't have been received any earlier than the day that it was made. So that's the starting point, after which, okay, at what point did Mr. Brown actually know of that appraisal's existence, what its number was?
Or should he have known?
Right. Right. And there was testimony about, when he might have found out about that number, or about that appraisal number, and Mr. Walsh coming in and saying, well, when I talked to him, he didn't mention it. And Mr. BASCIANO said, well, I first found out about it, I think it was February 8th. So there is a window of time between December 20th and February 8th in terms of answering your question of what the evidence showed. But look at the damages summary that they put in. The funding stops January 3rd, abruptly. That's the end. So this. But
the $360,000 was in that window between the time that they allegedly received the appraisal and the time that Mr. BASCIANO, allegedly received the appraisal. That's what I'm having a difficult time with, that claim. I don't see where the statute of frauds applies to a negligent misrepresentation claim.
Well, if you read the court's opinion in Puff and stuff, the whole theory of bank statute of frauds is to exclude any cause of action that relies upon an oral conversation, an oral agreement that isn't reduced to writing, that fits the definition of debtor and creditor and is in fact a credit agreement. And the fact remains that.
Well, that wouldn't be a credit agreement, though, right? I mean, that just little part of the case has to do with kind of like detrimental reliance. I mean, that case is, he's funding, the hotel. He's not even giving money to the bank, really. He's just putting money into the hotel, and he's saying, they had a duty to not to lie to me about, the appraisal coming in, because if I would have known about it, I would have saved myself that additional $360,000. I guess that's his theory.
That I think is about as close as you can get on what the theory is. But if you look at what the statute.
Okay. Forget about the statute.
Okay.
What other defenses do you have to that claim?
Well, the pre-negotiation letter, it covers exactly that scenario. Nothing that we say to each other can reasonably be relied upon. Nothing that we say to each other can be used in litigation. So how can there be negligent misrepresentation when the heart of it is we signed a letter in April saying, all right, now we can have a free-flowing, open conversation about how we're going to work this loan out that's in default after 1 year. And that's why that letter even existed. And so the pre-negotiation letter, it addresses precisely a negligent misrepresentation. You can't have reasonable reliance as a matter of law, and the cases that we cite say that, if you represented the fraud would be on the other side. If you represented that nothing we say to each other will be used against each as a basis for a cause of action except for negligent misrepresentation. It drives right down the heart of why you sign a letter like that. And what is the policy reason behind enforcing an agreement that says what we say to each other is not going to give rise to an enforceable claim or litigation? It's not a lender issue exclusively. This allows the free flow of discussion between lenders and borrowers all day, every day. Without it, and without the bank statute of frauds, lenders are going to have to file foreclosure. They're not going to have a choice because there's too much risk that what I say is going to be considered negligent misrepresentation or a novation or fiducto or whatever else you want to come up with. But
Ashby, let me ask you to change gears for just a minute. One issue that was raised in at the very tail end of your motion for summary judgment, but doesn't seem to be developed anyplace else, was you said bankers as a bank, fiducia doesn't apply, and you cite the statute.
Right. If you look at this.
And their response is about as brief as yours, and their response in their memo in response was, well, Lennar is the one that did all the bad stuff,
right,
and they're not a bank. And I never could find where the trial judge made any specific rulings on that or that issue's been raised on appeal. What's the status of that?
Well, it's specifically limited to oversight by the Department of Banking and Finance, I think, under the statute. But it clearly shows that the legislative intent is that the fiducia statute is not intended to apply to banking activities. And we cited two other cases that.
Well, but my specific point, though, was that the relevant version of it says it doesn't apply to banks and S&Ls regulated by the Department of Banking and Finance,
right,
or regulated by federal agencies.
Right.
So, and you put in your motion for summary judgment, although I couldn't find factual support for it, and everybody kind of was very abbreviated on this point.
Well,
you said we're a bank.
The trust is the Bankers Trust Company is the trustee for the trust which held the note mortgage at the time. But their response was that Lennar Partners isn't overseen by the department. But it still shows that the legislative intent is that this isn't supposed to be directed to banking activities. And that's why the application there was a reference to the exemption in the application, which was limited and excluded from banking activities. And a number of other courts have come to that conclusion as well. And we cited Judge Antone in the Shibata case and the Merrill Lynch case and the Thompson case, where they found that fiducia was not applicable to the types of trade and commerce that the FTC is targeting in the big deceptive and unfair trade practices statute. So we don't have the caliber of the type of activity to even get started with. And that's why it's so hard to fit the idea of a consumer in when, if you have a consumer in a bank setting, they're going to be trumped by the bank statute of frauds. And that's why there's a complete overlap. And that's why it doesn't fit, is because it's not supposed to fit. There's not supposed to be a fiducia claim in this circumstance. And that's what we argued, and that's why summary judgment should have been granted on that basis. I would be remiss, and I do want to save some time for rebuttal, if I didn't emphasize the fact that the March letters that were excluded at trial were the exclusion of those letters was extremely prejudicial. And here's why. The judge, when the trial court ruled that summary judgment was inappropriate on the remaining counts, it was only because there was a factual issue remaining as to whether Mr. BASCIANO had the hat on, that he was the borrower, or whether he had his own hat on, and he said he was wearing two different hats. And the trial court denied directed verdict on that, again, at the close of the plaintiff's case. So we know that was still a live, hot issue. And the letters that were penned in Mr. BASCIANO's own hand, where he says, me as the borrower, and signs it as managing member, and what point in time did those letters come into play? That was the culmination of all of these discussions that started with the kickoff of the April letter. Mr. Brown and Mr. BASCIANO, no dispute in the evidence and the facts, both agreed that Mr. Brown told them, put your best offer in writing, and I'll take it to the committee, and that's what those letters were. And so I have Alpha, which is the April letter, and I have Omega, but I don't get to tell the jury that, because he says, well, after the April letter was signed, I changed hats and I became my own person and I wasn't the borrower anymore. And the jury needed to see that, yes, indeed, in March 2000, the culmination of all these discussions, put your best.
Did the pre-negotiation letter come into evidence?
Yes. The April letter did, yes. There wasn't, they argued that somehow I had waived it because I said the release language didn't apply, but I think you understand the distinction that was being made was, I agree, you can't release fraud in advance, but that's not what we were talking about. We were talking about the application of the balance of the letter and whether, as a matter of law, you can reasonably rely on oral conversations when you say right up front that you're not going to. So I would like to reserve the remainder of my time for rebuttal, but if the court has any questions at this time. Thank you.
May it please the Court. Unless Your Honors would like to start with something specific, I'd like to move into one of the arguments.
I want to wait for you to say your name, and then I'm going to start with something specific.
I apologize. I'm Kenneth Missouri, and I'm here for the plaintiff, Richard.
I just didn't want to do to you what Judge Orfinger did to that fellow earlier on today. Ms. Ashby left with the two hats issue.
Yes.
Is that right? In other words, is that what was left for the jury to decide, what hat Mr. BASCIANO was wearing?
Absolutely not, Your Honor, because what the undisputed evidence was that Mr. BASCIANO paid $1.175 million of his own money personally at the encouragement and enthusiastic encouragement.
No, I guess you misunderstood my question. I understand what your theory is.
Okay.
But wasn't that kind of the central issue for the jury to decide here, whether or not he was acting in his communications with the bank, whether he was acting in a personal capacity or whether he was acting on behalf of the LLC?
No, Your Honor, it wasn't the central issue. Once we got to the time for a jury verdict, and I'll explain to you.
I mean, how can he bring a cause of action in his individual name if he didn't have some privity relationship with the bank?
Well, he had a relationship, and that is he entered into a deal, as everybody testified to fund the corporation, to keep the loan current, to make to perform all the renovations that needed to be performed on the hotel. Now, I
was reading in your brief here, page 8, where you highlight Mr. Walsh's testimony about what the deal was.
Yes.
And it says Mr. BASCIANO would have an opportunity to structure a deal based on that appraised value, or if Mr. BASCIANO did not like the appraised value, he had agreed that he would not legally contest the lender's position to take the property back.
That's correct.
That's the deal, right?
That was Mr. Walsh's description of the deal.
Well, that's what you cited in your brief as the deal. I mean, is that the deal or not?
That's the deal. Mr. BASCIANO also explained what the deal was in his testimony. So I would say
if Mr. BASCIANO was wearing his hat, his personal hat, when he made the deal, how does he have anything to say about the lender taking the property back?
Because he is the controlling shareholder. So he, in his individual capacity, could say, I'm not going to do anything to step in and keep this property from being foreclosed.
So is he acting, doesn't he have some sort of fiduciary responsibility to the LLC as managing partner of it?
Well, based on the facts, that's an interesting question because it was only a two-person LLC. He was the majority shareholder.
LLC's an entity, right?
Right, and Mr. Pacidi had defrauded him and obviously discharged.
So he's trying to cut the CD out of the deal altogether, is what we're debating here?
No, he's trying to salvage his investment. Mr. Pacidi walked away from this thing and left Mr. Basciano $4 million in debt and just didn't want to have anything else to do with it.
Mhm. All right, so what you're saying is Basciano, with his individual hat on, he's got a right to look at the appraisal and decide yea or nay, and if he decides nay, then he's going to use his capacity as managing partner of the LLC to make sure that the LLC does not contest the bank's right to take back the property. Is that right?
That's a fair characterization. I would modify it by saying he's just not going to do anything.
What evidence is there that he was acting in his personal capacity when he had these discussions with the bank?
Okay, the first evidence is that he personally funded $1.175 million out of his own pocket. And if I could show you some of the testimony, I'll show you the most important evidence to that regard. And
I assume it's this testimony that you cited in your brief, which I haven't found.
It's in the record. It's the same testimony. And what Mr. Basciano was asked was, did you agree with Mr. Brown that the appraisal would be the basis for your personal right to buy the loan? Yes, sir. And was the amount to be based on the appraisal? Yes, sir. And if you did not exercise the option to purchase the loan, to buy the loan from Lennar, if you were not going to infuse any money, if you would just quit funding and not contest the efforts by Lennar to take the property? Yes, sir. Was this Mr. Basciano a deal between you personally and Lennar? Yes, it was.
All right, I saw that. You've got that highlighted in your brief. Now, isn't that just a conclusion by him? Was this, you ask him, was this a deal between you personally and Lennar, and he says, yes, sir. That's just his subjective conclusion, right?
Well, it's testimony as to what the facts were.
Well, I mean, I thought from Contract 101 that the only thing that was important about what the contract is the words that are spoken by the contracting parties. This doesn't tell me anything about what the words were that were spoken by the contracting parties in terms of capacity, right? All this testimony tells me is that Mr. Basciano subjectively believed. You remember that objective theory?
I remember the subjective.
He subjectively believes that it was a deal that he made personally with Lennar.
Well, and here's what I would say, Your Honor. That subjective belief and that testimony was based on the discussions that he had with Chris Brown. And actually, while you're on that, I can show you some other testimony that's not cited in the brief.
Well, I was looking for some testimony about the discussions with Chris Brown where they agreed, not that he's going to personally fund it, where they talked about the fact that this agreement was an agreement between the bank and Mr. Basciano. You got anything like that?
If they're asking for Mr. Basciano to personally fund, they're saying you personally fund, and we will give you this option. It's an agreement between Mr. Basciano and
I don't know about that. I mean, I suggest to you that the bank doesn't really care where the money comes from at that point. They don't care whether it comes from, they don't care where the money comes from. The question is, who were the contracting parties, right?
Correct, and the evidence supported the fact that Mr. Basciano was the contracting party because they asked him.
Well, the pre-negotiation letter doesn't support that, right?
Well, I really would like to get into the pre-negotiation letter issue because it's important.
Well, just in terms of the signature block, it doesn't support that Mr. Basciano made this contract individually, right?
Well, the pre-negotiation, I would agree that Mr. Basciano did not sign the pre-negotiation agreement in his individual capacity, which is why it did not apply to him.
Nor did he sign the letters that counsel argues should have been admitted in evidence in his individual capacity, right?
That's absolutely correct.
So all the written evidence that we have, that we've seen in the record, suggests that he contracted in his corporate or his representative capacity, right?
I disagree with you, Your Honor. There was written evidence of his personal funding of the loan. You have to go back to that. The corporation had no money. It was shortfalling every month. Nobody could enter into a deal to do this except Mr. Basciano because he's the only one who had the money to do it. This was a non-recourse loan. He had no liability on it whatsoever. He could have walked away from it and would have had no issues whatsoever. but he agreed, based on the deal he reached with Mr. Brown, to personally fund $1.175 million of his own money. That speaks volumes as to what the deal was. The fact that it was a non-recourse loan shows you that there is a difference between the corporation itself and Mr. BASCIANO. And as long as we're getting into Contract 101, the objective theory of contract says that a reasonable person looks at the evidence, and a reasonable person determines whether there was a contract and what were the terms of the agreement. Well, who was the reasonable person in this case? It was the 6 jurors who looked at this situation and found as they did for Mr. BASCIANO. I also want to add that a Deceptive and Unfair Trade Practices Act claim does not even require an agreement or a deal in the legal sense. All it requires is that there is deceptive conduct and unfair conduct that harms somebody. And unquestionably, the evidence was 100% that Mr. BASCIANO funded this at the encouragement of Mr. Brown. The jury found that there was deceptive and unfair conduct. That's your case right there on productive. It's a simplified cause of action. So no matter how you slice it, you cannot get around the fact that Mr. BASCIANO funded $1.175 million of his own money when he had no duty to do so whatsoever.
Can you tell me what your theory is on the negligent misrepresentation?
I can. It's a two-pronged theory. The first is the one that you...
What does that mean? Throw everything at the jury and hope one sticks, or what?
No, Your Honor.
Okay, well, I mean, you know, how did you plead it? What's your factual theory?
The factual theory was two-pronged. One, that once they had the appraisal, Mr. Brown affirmatively told us he didn't have the appraisal, and that was proven at trial. The other is that they had...
No, take me out the rest of the way on that. He had it. He said he didn't have it. Okay, and he's doing it to induce reliance, and he does induce reliance, and the reliance is, just take me through that fact.
Okay. The evidence showed that as of about December 20th, Mr. Brown had the appraised figure. On December 22nd and January 6th, he told Mr. BASCIANO, I don't have the appraisal. I think it's coming in at 8.5 to 9. During that time period, in reliance on Mr. Brown's statement, I don't have the appraisal, please keep funding, Mr. BASCIANO funded $360,000. Now the rest of the
He didn't fund anything the only conversation he could have relied on would have been the 22nd, because he didn't fund anything after January the 3rd.
January 3rd.
So the second conversation was January the 6th. So
Fair statement.
there's only one.
Fair statement, Your Honor.
Okay.
And he didn't, the funding, the money he gave, the $360,000, he didn't pay that to the bank, right? He paid it to the LLC, right?
It went to the LLC, but a lot of it was paid to the bank in the form of debt service and in the form of...
A lot of the $360,000 was paid to the bank in the form of debt service?
Yes.
So they were servicing the debt up until January 3rd?
Yes, the loan was kept monetarily current and actually non-monetarily current ever since Mr. BASCIANO took over. Mm-hmm. I really do want to get to this legal representative issue because I think it's critical, and obviously you're concerned about it.
While you're addressing that issue, because I think it's relevant to the March letters that were excluded.
Yes.
Because the issue of legal representation versus individual capacity was relevant, why wouldn't the letters in March where Mr. BASCIANO, A, signs them in the exact same capacity, but yet refers to himself as the borrower, I will return the keys. Well, if he's not the borrower, he doesn't have the right to return the keys. It'll help me as the borrower. I understand your theory that these were settlement negotiations, but the statute makes very clear, the case law makes very clear, that if it's relevant for other purposes, it's admissible. So, A, why wasn't it relevant for other purposes, that is, to prove his capacity or lack thereof? And at the very least, why couldn't a redacted version have been put before the jury that would have taken out the concessions supposedly being made?
Okay. The only purpose that could have been relevant for, and the defendants argue it vehemently, is they say, we want to show that Mr. BASCIANO was acting on behalf of the corporation, and therefore we have no liability to Mr. BASCIANO individually. It goes directly to the issue of liability, otherwise it has no relevance. So what the statute says is you can't introduce a settlement negotiation for the purpose of trying to prove liability.
I
So-
thought that statute pertained to settlement negotiations between the parties who were who were litigating.
Absolutely not. The case law is entirely clear that it can be different parties if the issues are related. That's in the Reese case, and there's a...
Well, I mean, these are, Mr. BASCIANO is, these letters are between the LLC and the bank, right?
He signed them on behalf of the LLC.
Right.
Yes,
Yeah,
but
but there's a whole separate agreement that he made individually with the bank, right?
Yeah, which is, the discussions of that agreement are encompassed within the letter. It was a global offer to settle all potential claims of the corporation and him. And it's all tied into one core of facts, and that was that the defendants yanked the rug out from Mr. BASCIANO. So to finish, the only reason they wanted to introduce this is to try and show no liability. So it comes out. It clearly has settlement negotiations in it. It was related. The claims in there were
How does
related.
it show liability? You lost me. I mean, there's nothing in that letter where they're admitting that they're liable for anything. All it shows, all the plaintiff wanted, or the defendant wanted to offer it for, is to show the capacity in which he was dealing with the bank. Now that may be the linchpin factual determination, but that's not tantamount to liability.
Well, you got to go to the next step, Your Honor. Why would they want to prove that fact? What was the whole purpose of trying to prove the fact that you just stated? To show that they aren't liable.
Well,
Otherwise, it has nothing to do with anything.
But in that sense, counsel, then there is no such thing as an offer of compromise coming in for any purpose, because it's always a part of the piece of the puzzle to prove, the theory that the particular party is espousing. Right?
No, I think there could be collateral issues. You could be using it for maybe to impeach the credibility of a witness.
Well, they could have been using it to impeach Mr. Bassiano's credibility.
That's not what they said, though. They said they wanted to use it to prove that he was dealing in his corporate capacity.
That's the same as impeaching him, because he stated it would contradict what his trial testimony was, right?
No, they were trying to prove what they believe is a material fact. We disagree with that. It's not just credibility. They were trying to use the letter to prove what they claim is a material fact, that he was acting in his representative capacity, and therefore they are not liable to him. It goes directly to the exclusion. You can't get around it. And there may be other examples that I can't come up with right now, but I promise you that goes directly to the issue of liability. But Judge Orfinger, if I've answered your question, I'd like to move on. I also want to say, could it be redacted, or could it have been redacted? No, because both the statute and the case law is exceedingly clear that it says the settlement offer and all the communications that went along with the settlement offer do not come in. So you don't redact, and there is a strong policy of the state of Florida in encouraging a free flow of settlement negotiations. And if you start letting stuff like this into evidence, then you're vitiating that policy.
Was there a disputed claim at that time?
Absolutely.
Tell me what it was.
What it was they never offered him to buy the loan at $8.3 million. On February 18th, 2000, they said to him, "We're doing nothing. You get no discount. You get zero. Thank you for your 1.175. We're taking the property and you get nothing." At that point, there's a claim, and that's when he writes this letter 2 weeks later, or 12 days, 13 days later, and says, "Look, I'm ready to sue, and that's not going to be in anybody's best interest, so let's try and work this out."
There was a claim that belonged to Mr. Bassiano.
And potentially claims on behalf of the corporation. Sure, I mean, both.
You see, that's where you got me all confused. I mean, there has to be, the statute says there has to be a disputed claim. There has to be a dispute.
Sure.
And then an attempt to compromise that dispute.
Sure.
And the dispute, there wasn't any dispute between the LLC and the bank, was there? I mean, the LLC had signed this pre-negotiation letter. They negotiated. The negotiations didn't pan out.
Okay, that's a fair statement. If you agree that Mr. Bassiano was acting as individual capacity.
That's the position you all took. You have to be consistent in your position.
Yeah, we are.
If there's no dispute between the LLC and the bank, then there's no violation of the statute to admit an attempt to compromise between the LLC and the bank.
That's not correct, Your Honor, because there doesn't have to be an identity of parties between the people making the settlement offers back and forth.
I heard you say that argument, but this is a different issue. The statute also says that it has to be an attempt to compromise a dispute. And this letter was written by the LLC to the bank. And there was no dispute between the LLC.
If you look strictly at the signature, sure, Your Honor. If you read the content and you want to do substance over form, what Mr. BASCIANO says throughout that letter is, I've done everything I said I was going to do, and you pulled the rug out from under me. And yes, did he sign it on behalf of the LLC? Yes, you have a man with a 9th grade education signing things the best way he knows how. As you read the substance of that letter, he says, I abided by every commitment I made, and now I'm trying to compromise this, and I would submit
Now you're arguing reasonable inferences and facts and things like that. It sounds to me like the good people of the jury should have had the right to sort through all that.
No, because it was an evidentiary ruling as to whether it was an inadmissible settlement negotiation.
Ruling, yeah. All right.
Okay. And it brings up a good point. What is missing from this whole discussion about legal representative and whether he was acting on behalf of the corporation? They did not move for summary judgment on the grounds that Mr. BASCIANO was acting as a legal representative and therefore he had no cause of action. They did not raise standing as an affirmative defense. They did not seek a jury instruction asking the jury to determine whether Mr. BASCIANO was a legal representative or not. There was not a line in the verdict form asking the jury to make that determination. This was never an issue. The way this evolved was these agreements had this release language in it. And they were arguing that Mr. BASCIANO was a legal representative because it had this release. And then at trial, there was a stipulation made, and the court summed it up. And the court said, let me make sure, and this is the court talking to Ms. Ashby, let me make sure I understand what that hair split is, if you will. You do not intend to argue to the jury or request a jury instruction that there is an open question about whether Mr. BASCIANO is a so-called legal representative, and therefore that the able document released him in any, or released his claims that he may have in any respect. And then she said, not the remaining claims. This issue went away. And then what she said was, recognize that this case has been a long and winding road. Where we are now is this document goes straight to the issue of justifiable reliance, which is an element of both the claims. So what she argued to the jury is he couldn't justifiably rely because this agreement said that as a matter of fact. Oh, okay. Thank you. We'd ask you to affirm the judgment based on those arguments. Thank you.
We read your briefs, counsel. Thank you. We read your briefs.
Yes, sir. I wanted to clarify, if it was unclear earlier, that Lennar was Banker's agent as special servicer, and I think that was clear in the record, and hopefully that we made that point in our briefs. In answer to your question, Judge Torpey, about what the negligent misrepresentation was that was pled, that we went to trial on, page 206 of the record, paragraph 52. On numerous occasions, Lennar, Pacific Life, and Bankers negligently misrepresented to BASCIANO that Bankers had not received the appraisal when, in fact, Bankers had received the appraisal and decided not to make any good faith effort to restructure 3835's loan. So that's the point of demarcation, and there can't be negligent misrepresentations until the appraisal exists on the planet, which is December 20th, which is why the court granted the remitter, but hopefully that answered your question. I'd also like to point out that Mr. BASCIANO did not spend $1,175,000 of his own money. He was still running through that 3.2 he took out of the closing, and you can see that from those damage summaries that he introduced. I don't intend to relinquish any of
Wasn't his claim as to that the 3.2 that he took out at closing was money he'd already put into the deal? He was just getting his own money back.
He said that it was paying off another loan. He didn't make any other clarification about whether it was for this property or some other property, but he was running it all on the same sheet. So if you look at, these are his sheets, so if you look at that summary sheet, he's running money up to that point, then he takes 3.2 out, and then he's putting it back in, and hasn't put back in what he took out from the closing on this deal. And it shouldn't be overlooked that at every juncture, a key component of the negotiations and discussions that they had was that if Mr. Bassiano didn't like the offers and proposals and numbers that they bandied about, that he was going to give the keys back. And you can't give the keys back if you're not the borrower who owns the property. And that was the problem that they could never get past. It's because Mr. Bassiano, Mr. Brown, this is what was always, and Mr. Walsh, this was always a component part of it. And it also leads to the problem that we alleged in our point number 3, which is it's sand. It doesn't hold anything up because it's a non-mutual agreement. Mr. Bassiano can walk out the back door. There's no liability that flows to him. It's therefore not an enforceable agreement. Fendrick would have been an enforceable option, but for the fact that both parties had the ability to walk away. Why this is distinguishable in this case is because in Fendrick he had a specific lot and a specific price and a specific time. We don't have any of those things here. We don't know, there was no agreement about any of the material terms to support any sort of agreement, and that's why it doesn't hold up any cause of action.
There doesn't have to be an agreement, though, for there to be a tort of negligent misrepresentation.
I would agree with that. I would agree with that.
And that, I mean, you and I both know what the elements are of that tort, and I'm still having difficulty with that one. I heard your argument about the statute. Why doesn't that tort fit? If you take all the reasonable inferences and all of that, I knew he was pumping money into the thing. He's saying that, if I'd have known what the appraisal number was when it came in, I would have quit pumping money in. Whether that's logical or not, really wasn't up to the jury.
But the statute of frauds is clearly a question of law. That's not a question to go to the jury. And the bank statute of frauds is precisely for this exact type of situation, and it eliminates all causes of action. And why? Because if we leave the door open for any specific tort, then oral conversations can no longer happen.
I used to have this come up in the construction context where, the bank was telling these subcontractors, don't worry, we're going to get you paid, and they keep working on the project. Are you saying that kind of behavior does not give rise to some sort of a cause of action?
It does not, unless there are agreements to the terms, because all the cases that we cited, and I see that I'm out of time, but if I may just answer your question.
All right, you answered the question. Thank you.
Okay. We would ask for the court to reverse. Thank you very much.
Thank you. Please stand in recess.